Assalamualaikum warahmatullahi wabarakatuh. My name is Najwa Sophia binti Abdullah Adnan. My matric number is 1911238 and I am from section 3. So today I'm going to present on the case review which is titled Alliance Bank Malaysia Bhd against Ragam Handal Sdn Bhd and others 2011 MLJU 1434. So this case it was held by the High Court Kota Kinabalu and the judge involved in this case is Stephen Chu. So the judgment date of this case is 1st July 2011. Okay, so here's the fact of this case. Okay, Ragam Handal, he was the defendant which was appointed by Lembaga Pembangunan Perumahan dan Bandar as a turnkey contractor. So he was supposed to build 1,000 units of double-story low-cost terrace house on Lembaga's land, and he had signed a supplementary agreement. And he also applied for a bridging loan from the plaintiff, which is Alliance Bank Malaysia, a bridging loan of 7 million ringgit with an overdraft facility of 500,000 ringgit and a banker guarantee of 2 million in order to finance the construction works. So the first defendant, so the first defendant, he had completed phase 1 to phase 5. However, there was a dispute on completing phase 6. Okay, phase 6, it was divided to 3, which is phase 6A, phase 6B, and also phase 6C. Okay, so phase 6A, it would consist of the defendant would build 116 units of double-story terrace low-cost houses. Phase 6B, he would build 20 units of shop houses, and phase 6C, the remaining 4 units of the shop offices. Okay, so he approached the bank for additional facilities. However, he failed to repay, and it was found out that the defendant failed to complete phase 6B and also 6C. So in this case, the defendant had a failure to repay the bridging loan and also the overdraft amounting to 3.5 million. Good, and so there are two legal issues involved in this case, which is firstly, whether the defendants were under duress and coerced into agreeing and signing the security documents, including the first set of guarantees in respect of the banking facilities offered by the Alliance Bank, and secondly, whether the defendants were under duress or coercion by the plaintiff into executing the letters of offer for additional banking facilities. Okay, so before we move further into details, let us look at the definition of coercion. Okay, so under section 15, it was stated that there are two ways in proving coercion. First, the commission or the threat to commit or of any act which is forbidden by the penal code, and secondly, the unlawful detention or threatened detention of any property to the prejudice of any person. And under section 73, this act shall provide the liability of a person to whom money is paid or thing delivered by mistake or under coercion. So next, okay, so here's the defendant's argument. Okay, so the first and second defendant, they argued that they were under duress and coerced to agree with the term and conditions which is set out for the initial banking facilities under letter of offer. And secondly, it was stated that the bank had acted in bad faith because the bank had coerced them to sign the terms and conditions and the agreements. And it was stated that there was no reason for the first defendant to execute further letters of offer and additional securities, as the additional releases drawn down were under the existing of the bridging loan. So they argue that why they don't have to even sign the letters, and that the bank had acted in bad faith in requiring the second and subsequent letters of offer and also the additional securities which is offered by the Alliance Bank, and that they argued that they were coerced and under duress to sign the bank security documents, including the two sets of the guarantees. And also they argued that it was actually the failure on the part of Lembaga instead of the defendants himself. Okay, next. So the plaintiff counter-argued by saying that the defendant, he could approach other banks if the terms and conditions which is offered were actually contains an unfair and unacceptable agreements, and they said that the defendants could refuse, walk away, or approach other banks if the terms and conditions offered were unfair and acceptable. The defendants, he don't even have to agree with the and accept with the offer if he found that it is unfair, and he was under no obligation to do so. But the defendant, he insisted and signed the agreement, and it was stated that it was the defendant who approached the plaintiff for the additional facilities after the amendments to phase 6 of the development. So actually from here we can see that it was the defendant's idea to change the phase and divided it into 3, because actually the plaintiff only wanted it to be units of double-story low-cost houses. Okay, so here are the judgments. Okay, so the evidence showed that the second defendant, and they agreed and accepted the terms and conditions set out in the letter offered, and they also were not under duress and coerced into signing the first set of guarantees and the security documents in 1999 to 2000. And there was also no duress or coercion on any of the defendants to sign the second and subsequent letters of offer, and for them to provide the additional securities to the plaintiff. And it was the defendant who approached the plaintiff for the additional facilities after the amendments to phase 6 of the development. And furthermore, the defendant, he had more than sufficient time from 2000 to have approached and moved to other banking facilities, other banking businesses, if they were not happy with the existing bank customers relations. But the defendant, he did not do so. He just continued with the offers and agreements with the Alliance Bank. So from here, we can see that the bank and lembaga were not the one in breach and not at fault in respect of their separate obligations to the defendant. And the court found out that there were no merits in the defendant's respective counterclaims against the bank and also lembaga. So in this case, it was held that the defendant's counterclaims are dismissed with cause. So the evidence showed that the second defendant, he had agreed and accepted to the terms and conditions laid out in the offer letter, and they also subsequently signed the guarantees in their own personal capacities. So the evidence showed that they were not under duress or also coercion into signing the agreements. And secondly, there was also no coercion or duress on any of the defendants to sign the second and subsequent letters of offer for them to provide the additional banking facilities to the plaintiff, to the defendants. And it was also the defendants who approached the plaintiff for the additional facilities after the amendments to phase 6 of the development. And next, let's say if the defendants were really under duress and coerced into signing the agreement, then why did the defendants still go to the bank and requested for the additional facilities in 2005, 2006, and also 2007? And if they were really under duress and coerced to sign the letters of offer in 2005 and 2006, then why did they go again to the bank in 2007 for the sum of 680,000 ringgit? The defendants, he had more than sufficient time from 2000 to have approached and moved to other banking businesses if they were not happy with the existing bank, which is Alliance Bank. But the defendant did not do so. So it was found out that there were no merits in the defendant's respective counterclaims against the bank and also lembaga. So the defendant's counterclaims are dismissed with cause. So for the final part of this presentation, I will do the comments and also the analysis. So in this case, the question to be posed is, was the defendant really coerced by the plaintiff to sign the agreement? So in this issue, the main concern of the plaintiff was regarding the failure of the defendants to repay back the bridging loan and also overdraft. So there are a few conditions which is laid down under the case of Muhammad Farid Subramaniam against Nazar Motor Trading Sdn Bhd. So if the defendant wanted to prove that he was coerced and also under duress, he must fulfill the conditions as follows, which is firstly, whether he did or did not protest. Secondly, whether he did or did not have an alternative course open to him. Third, whether he was independently advised. And lastly, whether the defendant, after entering the contract, he took steps to avoid it. So, in this case, the court considered that they were not under duress or coercion because the document was signed during the stage of negotiation. So he had an ample time to ask if he thinks that the agreement is unfair and also unreasonable. However, they did not do so. They still continued with the agreements, and the defendant actually had the alternative to reject the agreement if they did not agree with the terms and conditions set in the agreement. And it was found out that the defendant did not even protest before signing the security agreement. In that sense, the economic duress will not be applicable in this case. And in my view, it is believed that the court's decision is accurate as there were no coercion proved under either section 15 under the second limb or the first limb, and the defendants were not under duress following the Muhammad Farid and Subramaniam's case, which laid out the conditions needed to be followed. And regarding the second issue of whether the defendants were really under duress and coercion by the plaintiff into executing the letters of offer of additional banking facilities. Under this issue, the agreement was about the additional banking facilities which is applied and granted to the first defendant in order to complete the amendment to phase 6C of the construction. And the court was in the opinion that the defendant were not under duress and also coercions on the ground that the defendants had accepted and signed the first and second letters of offer without any complaint of duress and also coercion at that juncture. And furthermore, upon signing the third letter, he had an advocate with him, and the evidence showed that the defendants did not complain about any duress and coercion put on them by the plaintiff. So the court will also consider that they were not under duress and coercion because in 2007 they could have taken back and set aside the agreement if they found out that it was unfair. However, and also they had also an ample time to go and approach other banking facilities. However, they did not do so. And so from my standpoint, I agree with the judgments by the court because the defendants had failed to prove that the plaintiff had acted in any manner prescribed under Section 15 of the Contracts Act 1950, which talks about coercion and also duress. And the court's decision in dismissing the defendants' counterclaims is a rational decision. Thank you.